So I split the Establishment Clause cases. There are a lot of them, and I'm only covering some of them. But I actually have 3 slides just on the Establishment Clause cases. I split them into kind of funding-related ones, which is what this one is. One's about prayer, and one's about display. So the first one, Bradfield versus Roberts, and I'm going to have to look at my notes a little bit here because I can't remember this stuff either. This is where the federal government actually funded a hospital operated by a Catholic institution. And the court ruled that funding was actually to a secular organization, and the fact that it was Catholics running the hospital didn't matter. So this one is in 1899. So therefore, it's permissible. They're funding a hospital. It's a one-time charge. It's not something where the government's involved in the hospital, and it was funding the building. It wasn't funding the Catholic Church. And at the time, the Catholic Church in this hospital wasn't turning away anyone based on religion. So they really had no right to stop this. So here's one where the Supreme Court said, no, that's fine. And then in 1947, in the Everson case, there was a funding of student transportation to schools, whether parochial or not, okay? And this is in New Jersey. And they upheld the separation of church and state on this, saying the clause against establishment of religion by law was intended to erect a wall of separation of church and state. So this is one of the first court cases where they actually used that clause. And in this case, they said that the government could not fund transportation to these schools because it was primarily to religious schools. Okay? And then the Lemon case. And this is a hallmark one. It changed kind of the whole texture of court rulings on this and gave them what's called the Lemon test, which I mentioned up here, and the next slide is about the Lemon test. So this is where the court decided, and they kind of added this new stance on this, that the government couldn't get excessively entangled. And to me, it's very vague. But they couldn't get excessively entangled with a religious organization. And so there are times in later cases where if it's a one-time deal, it's okay, but if you're doing this over and over, you're now entangled with the religious organization, and you can't do that. So it starts getting very picky about it. So in this case, let's see, the case is involving 2 state laws, one permitting the state to purchase services in secular fields from religious schools, the other permitting the state to pay a percentage of salaries for private school teachers. And the case basically got so complex because of how the government was trying to interact with these religions that the court came out with this, you can't be entangled in religions clause. And it ended up forming the Lemon test. And I'll do that, I'll talk about that on the next slide. Then in 1973, this is in New York and Pennsylvania, they elected laws where tax revenues would be paid to low-income parents to permit them to send students to private schools. So they knocked this one down because, and they talk about this over and over, they basically look at private schools as synonymous with religious schools. And it changes later because a lot of non-religious schools started coming about that were private. But at this time, pretty much all of the private schools were religious schools. So they use the term interchangeably. If they call it a private school, they're considering it religious. And they said they can't do that because it's specifically for religious reasons. Because they were doing it to get them to religious schools. Okay? And then in 83, this is in Minnesota, there was a statute permitting the use of tax revenues to reimburse parents of students again, right? The court noted in this case, though, that it was specifically worded that it was allowed to pay for them to go to private or public schools. So again, private, religious, public, secular. Because the wording was such that the vouchers could be used for either one, they allowed it to stand. Very subtle differences, right? It's not going to be used for public schools in the most part because you're going to go to one near you. So the wording in it allowed the Supreme Court to change their ruling on that answer, but it's not that they're reversing anything, it's that the wording is different and now it's for secular purposes as well. 71, and here's again, the court permitted the use of public funds for the construction of facilities for higher schools of institutions, higher level of learning. And it found, in this case, and here's a case where they said it's not excessive entanglement because it was a one-time contribution to build this addition to this university. And because it was a building, it wasn't religious or not, it was just a building. And so they allowed it to stand. And then we get up to 2002, and this one is about school vouchers specifically. government aid for students to attend private and predominantly religious schools. Now they've changed their wording a little bit. They upheld the constitutionality of private school vouchers, turning away the establishment cause. But this was reversed in a this one basically ended up reversing the 1973 case, because they're saying that you can provide vouchers to private schools. But I think that has a lot to do with the fact that private schools have changed at that point. Now they're no longer just religious. I know it's dry. So the Lemon Test, and this is what the thing that kind of changed the way the courts look at these cases. They came out with these three, what they call prongs. One is the government's action must have a secular purpose, and it can't have a religious purpose. That's where you have to start. And the first two actually they started using before the Lemon case. They just kind of combined all these into a test at the end of the Lemon case and said you have to pass this test in order to come to court. The second one is the government's actions must not have the primary effect. Keep that word primary, because in a couple of cases it can be the secondary effect. But it can't have the primary effect of either advancing or inhibiting religion. Right, so it really shouldn't be promoting or denying religion, either one. It shouldn't have anything to do with it. And then last one is this entanglement piece. And to me it's the most vague, but it does allow them to say you can't get ridiculous about this. You can't make this so complex that nobody can figure out whether or not you're contributing to the religion's promotion or not. And so it's kind of, if any of these three prongs are violated, then it's not constitutional. Okay, so back to the Establishment Clause. I promise, not too much longer. 2 more pages of Establishment Clause cases. Then we can go to the Free Exercise Clause. So in 62, these are the ones that are specifically around prayer. And there's a number of cases on prayer, and what you'll end up finding in these cases is they start out saying, well, you can't do this, and then somebody finds a loophole, and it goes all the way to the Supreme Court or somewhere, and they plug it by saying, well, you can't do that. And somebody finds another loophole, and it goes all the way to the Supreme Court. So this is a continuing battle where people are trying to find ways to bring prayer to the school, and the Supreme Court is saying, no, you can't do that. So it starts in New York, which actually required daily prayer, which read, Almighty God, we acknowledge our dependence upon Thee and beg Thee blessings upon us, our parents, our teachers, and our country. And the Supreme Court struck it down. That's a pretty obvious one. You can't have them requiring people to pray a particular prayer. No problem. So 1963 comes out, mandatory reading the Lord's Prayer in class, right? The Supreme Court introduced the secular purpose and primary effect. So those are the first 2 of the Lemon tests that I told you about. So this is in 63, right? And then in 85, there were students in a public school who would observe a daily period of silence for the purpose of prayer. So they're not requiring them to pray. They're just saying you have to be silent for the purposes of prayer. So the court didn't find this unconstitutional because it ruled that Alabama, this is in Alabama, it ruled that Alabama lawmakers had passed a statute solely to advance religion, thereby violating the secular purpose. So they found this one unconstitutional and said you can't do that. Even though you're not requiring the person of prayer, you're doing it to advance religion. And the government can't do that.